Hello and welcome back to my YouTube channel, Legal Information, Law Insights. I am Advocate Mukund Mahajan. Today, we are discussing a very important constitutional question: is the President of India above the Constitution? We'll also explore the role and powers of the President and clarify whether the President can interfere in Supreme Court matters. Background of the current scenario. This discussion gains importance due to a landmark moment in Indian constitutional history. On 13 May 2025, for only the 8th time, the President of India invoked Article 143(1) of the Constitution, seeking the Supreme Court's advisory opinion on 14 significant constitutional questions. This came after a key judgment of the Supreme Court on 8 April 2025 in the Tamil Nadu Bill's Assent case, where the court held that a governor cannot delay assent to bills indefinitely. In this case, the governor of Tamil Nadu had withheld assent to 10 bills for several years. The Supreme Court ruled this action as unconstitutional and arbitrary, holding that governors must act on bills within a reasonable time, ideally within 3 months, under Article 200. This triggered major constitutional queries. Can courts impose time limits when the Constitution is silent? Does a governor have unchecked discretion to delay bills? Do similar constraints apply to the President under Article 111? To clarify, the President referred 14 such questions to the Supreme Court under Article 143(1) of the Constitution. Here, we will discuss whether the Supreme Court is bound to give an opinion on these 14 questions referred by the President under Article 143(1). Who is the President under the Constitution? The President of India is the constitutional head of the Union Executive and the ceremonial head of state, established under Article 52. The President is elected by an electoral college comprising elected members of both houses of Parliament, elected members of the state legislative assemblies. Role and powers of the President. Under Article 53(1), the executive power of the Union is vested in the President and exercised in accordance with the Constitution. Key powers and functions. Article 85, summons and prorogues Parliament. Article 111, gives assent to bills or withholds returns them. Article 75, appoints the Prime Minister and, on their advice, other ministers. Article 72, grants pardons, reprieves, and remissions. Article 53, to Supreme Commander of the Armed Forces. However, under Article 74(1), the President must act on the aid and advice of the Council of Ministers. This is mandatory as per 42nd and 44th constitutional amendments. Is the President of India above the Constitution? Absolutely not. The President is bound by the Constitution and cannot act beyond or above it. Why? Supremacy of the Constitution. The Constitution is the supreme law of the land, and all authorities function under it. President is a constitutional authority. All presidential powers are derived from and limited by the Constitution. Oath of office. Article 60. The President swears to preserve, protect, and defend the Constitution and the law. Judicial review. Even presidential decisions can be subjected to judicial scrutiny if they violate the Constitution. Doctrine of constitutional supremacy, enshrined in the Kesavananda Bharati v. State of Kerala, 1973, judgment. Provisions showing President is not above the Constitution. Preamble. We, the people of India, give to ourselves this Constitution. Indicates that the Constitution is above all. Article 53. One executive power is vested in the President but must be exercised in accordance with the Constitution. Article 60. Oath to uphold the Constitution reinforces constitutional obligation. Article 74. One mandatory advice of the Council of Ministers ensures accountability. Articles 32 and 226 empower the Supreme Court and High Courts to strike down unconstitutional acts, including those by the President. Article 361. 1 provides personal immunity to the President during tenure, but decisions can still be reviewed judicially. Kesavananda Bharati case, 1973 declared constitutional supremacy and judicial review as part of the basic structure doctrine. Can the President interfere in Supreme Court matters? No, the President has no authority to interfere with the judiciary. Reasons: 1. Separation of powers. Constitution divides power between legislature, executive, and judiciary. President is part of the executive and cannot interfere with judicial functions. 2. Key provisions. Article 50, separation of judiciary from executive. Articles 124 to 147, structure and powers of the Supreme Court, no room for executive interference. Article 142, SC decisions are binding and enforceable across India. Articles 32 and 226 empower courts to enforce fundamental rights and invalidate executive actions. Article 74. One president cannot act independently. 3. Judicial precedents. Kesavananda Bharati, 1973 upheld independence of the judiciary. S.P. Gupta vs. Union of India, 1981 rejected executive control over judiciary. R. Gandhi case, 2010 struck down provisions allowing executive control in judicial appointments. 4. Permitted judicial role of the President. Article 124, to appoints SC judges on the recommendation of the Collegium. Article 72, can grant pardon after judicial process concludes, not during proceedings. Article 143, can seek the court's advisory opinion, but cannot issue directives. Why did the President refer 14 questions to the Supreme Court? Under Article 143(1), the President may refer important questions of law or matters of public importance to the Supreme Court for its advisory opinion. In this case, it relates to interpretation of gubernatorial powers. Role of the President under Article 111. Constitutional conventions and time limits. This helps prevent constitutional conflicts and ensures clarity in governance. Is the Supreme Court bound to reply? No, the Supreme Court is not bound to give an opinion under Article 143(1) to the Honorable President of India. It is discretionary. If the court finds the question non-justiciable or hypothetical, it may refuse to answer. Even if answered, the opinion is advisory and not binding on the government or President. This preserves judicial independence and respects constitutional boundaries. Conclusion. Let's summarize key points. The President of India is not above the Constitution. The President acts within limits defined by the Constitution and must follow the advice of the Council of Ministers. The judiciary is independent, and the President cannot interfere with court functions. The President can seek advice under Article 143, but the Supreme Court is not bound to respond, and the advice is non-binding. This balance of powers maintains constitutional supremacy and democratic integrity. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.